Hello everyone, thanks a lot for having me. It's a great pleasure to be here again as last year. I hope I will be always moving close to the microphone because I have a tendency to move. So what I thought about when I saw the name of the panel, I thought it would be interesting to look at this idea of a passive and neutral intermediaries and look at the concepts, where they come from, and what are the policy goals, why we are actually having those debates at all. I'll try to be a little bit provocative, so I'll be happy if you disagree with me, because that's the point of this exercise here. So let me start with where this whole thing started. Why do we even discuss such things as passive, neutral, active, intermediaries, etc.? So as David's very nicely explained, and it's fantastic. We didn't coordinate that, but it's really great. Already in the drafting stages, there was a debate to what extent this language should maybe attach to some of the provisions, because of the concerns that existed that might be shielding some intermediaries that shouldn't be shielded according to some representations. Now, it never made it to the law. And also, if you look at the press releases of the Commission at the time, it was clear that any reference to passive intermediaries were references to mere conduits, and at most also to caching providers. So you can go and see, the press release by the Commission, and you see that this is what it is referring to. But of course, then since there was nothing in the law specifically, the first time when sort of a court had to get its hands on was basically Google France, right? And in Google France, maybe you remember, there was this Advocate General, Maduro, very famous Advocate General, who wrote a lengthy opinion on Google France. And in this opinion, he was saying several things, and he actually originally proposed to reject that Article 13 applies to keyword storage. So that was his proposal. Now, very important thing is that he came up with the following idea. He said, I construe Article 15, mind you, not Article 14, 15, as the very expression of the principle that service providers which seek to benefit from a liability exemption should remain neutral as regards the information they carry or host. Okay, so Maduro was of the opinion that, well, it's implicit in Article 15 that actually service providers shouldn't benefit from this in case they're not neutral, and this is where neutral comes in. And then this term is used later as a sort of you could say a synonym to passive-active debate a little bit later on. Now, interestingly enough, apart from the fact that he came up with this idea that there should be limiting principle, neutral or passive, active, there was idea of why and how this should be tested. And I think the most important part where he explains how he looks at this was when he says, well, active position, and he was basically denying that this safe harbor applies to keyword advertising exactly because Maduro thought that keyword advertising is too active. And the idea was that Google has active position here, as opposed to its organic search, which in his view was neutral, because it has a direct relationship with advertisers and has a direct interest in internet users clicking on the ads. So if you look at the arguments, I think this is really one of the main ones where he explains his thinking. And the question is what he really means by this test, right? I would argue that what he wanted to do, because also when you read other parts of the decision, it was clear that the judge was very inspired by contributory liability in the US, while noting that there's no such thing in Europe, at least on the European level. I think the court was Maduro was thinking about what about injecting direct financial benefit kind of idea to the entire European framework, and of course we can argue whether that's really the case. Because what happened is that at Google, that the Court of Justice eventually rejected this test, but retained the notion as a limiting principle in its case. So what did the court eventually say? It did not say it comes from Article 15, but it says, well, I accept neutrality criterion, but I will place it to the recital 42, where recital 42 is saying that some services should be indeed only passive, technical, and automatic. Though I think if you read that recital, it's clear that it talks about mere conduit and at most also about caching, but certainly not about hosting services. But the court based it on recital 42, right? And the court then came up with the idea that it is necessary to examine, for these purposes, whether the role played by the service provider is neutral in the sense that its conduct is merely technical, automatic, and passive, pointing to the lack of knowledge or control of data which it stores. This all comes from that particular recital. But at the same time, court rejected a test proposed by Maduro. So it adopted the idea, but it rejected the test. Because Court of Justice did not follow Advocate General, arguably, and it applied Article 14. It said, well, it's up to national courts to decide whether there is some form of active role, but dismissed the idea that the somehow direct financial benefit would be the disqualifying principle. So if you look at what the court is saying, of course it doesn't say so explicitly. In my view, it says basically the fact that you receive money for this, you set terms of service, etc., does not necessarily make it sufficient to say that you are somehow active. And I think many people and many member states interpreted this eventually as saying, well, indeed, just mere toolkit which allows you to register keywords without some additional active interventions wouldn't be sufficient to say that Google, with respect to keyword advertising, disqualifies. Now, what court suggested at the same time was that a role played by Google in drafting the commercial message, which accompanies the advertising, is the relevant thing. So how does Google behave when it helps its users, in this case advertisers, to actually draft a commercial message? And the court said, well, that's up to you guys at the national level to figure this out. Eventually, I think in many member states, the conclusion was that that Google was fine. Now, then came Laurel and eBay, as Martin already said in a very early morning. And interesting thing happened is that another Advocate General, Jaskinen, a fantastic Finnish lawyer, criticized basically this idea of a neutral provider. And it says, well, Article 42, Recital 42 is not where this is based on, and I have hard time to basically be convinced by this test. And Advocate General here advances view that, well, that recital is about mere conduits and caching, not about hosting. But of course, it respects the case law, and the court went, okay, so if we have this neutral and non-neutral, or active versus passive, then we should split the activities, because safe harbors are about activities, not services. We should split the activities, and with respect to activities that go beyond passive, we should basically go to the national law. With respect to those that remain passive, we should still apply Article 14. Now, Court of Justice responds. Court of Justice responds and says, well, okay, I didn't really mean it's only Recital 42. It's the entire Section 4, which is called Intermediary something, Character of Services.
Society services.
Exactly. So that's the title, because it's implicit in being an intermediary that this is it. Exactly. And it's implicit in this. And the court says, well, the mere storage, setting of terms of use, remuneration is not enough to lead to denial. But it wouldn't be okay to provide assistance which entails in particular optimizing the presentation of offers for sale in question or promoting those offers, right? And then court devises a test where it says, well, playing an active role means the following, and you cannot rely if you play an active role with respect to that data on a safe harbor. All right, that sounds very messy, so let's show in pictures what it means. I don't have a ticker, so I could point you, or maybe I do. No, this one probably won't do. So what this really means is that after Laurel and eBay, it became clear that then if you have, say, two pieces of content, A and B, right? So that's the scenario one. And you expose the first piece of content, A, to passive activity only, then of course you have a safe harbor. No problem with that. If on the same service at the same time you also have a piece of content B, which you expose to active activity, then for the piece of content B, you don't get a safe harbor. That's clear. That's not really problematic. Now, what about scenario 2? And this is where really eBay is about, right? You have a same piece of content A, and you expose it to passive activity as well as active activity, or active intervention. And the question is, what is the outcome? Now, Advocate General So the question was, what is the outcome? Advocate General, in my view, had a slightly different take on this than the court. Because the court says, well, basically, if you deviate by being active, you contaminate it for that particular piece of content, hence there is no safe harbor. So you don't necessarily split the two, if possible. But there is a difference if you now compare it to the scenario 3, where you imagine the same scenario, where you have one piece of content exposed to active and passive, but they can be separated. Now, the Advocate General's view, and my reading was that with respect to the passive intervention, for that part, you could say that safe harbor still applies. But with respect to the active intervention, of course, that's where the safe harbor doesn't apply and you have to go to the national law. Now, if you look at a court, the court seems to assume that you cannot really separate the two, and it's always basically active intervention somehow leads you outside of the safe harbor. Whether that's really the case, or maybe whether this distinction is completely artificial, it's up. We can see maybe in the future in the case law. But I think that's a really interesting one because it's not always the same scenario as it happened in eBay, where you have basically something posted by a third party, which is then taken up and advertised, which is a clear intervention. But you can have situations where something is hosted, and then there is some form of active intervention, which is not completely that you take and adopt the content, but say, for instance, you do predictions on top, which wouldn't qualify for safe harbor. Now the question is, the fact that you do predictions also disqualify you for liability exemption for the storage, just because you also have that part of the business? I think that's something that could become relevant in the future in some areas. All right, but what did it mean in terms of consequences? In terms of consequences, well, in trademark cases, it meant, of course, immediately following Google France and Allure and eBay, that co-drafting of keyword advertising is not covered. So in case you would draft the keyword advertising message as Google somehow, they wouldn't be covered. Or co-promoting or optimization of third-party ads would not be covered. So eBay taking the ads and basically advertising it on its own also would not be covered. Of course, the main thing that started happening was in the copyright case law, especially what we saw recently, is that entire debate about a co-intervention in the communication to the public by active providers. So what happens when people somehow co-intervene in communication to the public of other people, to what extent that brings them outside of the safe harbor and attracts completely direct liability. And I'll show that visually in a second. I think a really interesting impact was in defamation cases, and this is a growing trend, and I think one of the speakers today will also talk about it from Polish perspective. We saw basically national member states, the national courts, sidestepping the e-commerce directive on the basis that the kind of providers that they face, in their view, are active intermediaries. So, an example, of course, is a Delphi case, where Estonian Supreme Court was of the view that it can apply strict liability in the domestic law, as basically holding a news platform with respect to the comments liable as a publisher, because the e-commerce directive has nothing to say here, because it's an active host from that perspective. Same from Hungarian Supreme Court, which again sidestepped the safe harbors applying strict liability in MTE case, again thinking that safe harbors have nothing to say in this case. And as I've just learned, there's not a Polish case basically going again the same direction. In other words, this provided a way how you can easily waive safe harbors and say, well, I do what I was doing until now, and I just try to justify it as under this policy lever. Now, interesting thing that happened, and I think that's probably where the impact will be the biggest, is the fact that when Delphi made it up to the European Court of Human Rights, the court accepted it as a factor for discussing whether Article 10 is being infringed when you expose an intermediary to some form of liability. So when you look at the paragraphs 145 and 146, where the court discusses one of its elements of whether that's permissible from the human rights perspective, from the freedom of expression perspective, which is about the context of comments, there the court goes through the Delphi judgment and eventually concludes saying, well, it was relevant that you concluded that in this particular scenario, Delphi was actively soliciting comments, which you of course always do when you open a comment section, and hence that was relevant for the consideration that maybe in this case we should apply a more stricter standard to you than in other cases. And that, of course, is something that is taking the life of its own in the national case law now, because Delphi is construed as something completely different than it really is. It's a permissibility case, but in many national, in the national case law is very often construed as a case of what Article 8 prescribes, not what Article 10 allows, which is, of course, a very different inquiry. All right, so let's look at the rationale in this. So if you look at Google France and Laura on eBay, well, they both are based on this idea that there's an inbuilt implicit limitation of the system, right? So it cuts through all the safe harbors, it implicitly limits the entire system, and it's a universal precondition for all the safe harbors, right? It undercuts all the safe harbors. But the question is, what does it really do? What is it taking care of? What's the purpose of this whole test? Because we see now how it got there, right? So the legislators couldn't make it. Court accepted the criterion from the Advocate General that had idea of its own, arguably about direct financial benefit. The court did not really say much about why it's looking at the active role and how active that role is. And what is it really doing there? So you could say, well, it's preventing misuse by some form of intentional collaboration between intermediary and third parties, but that is taken care of by the knowledge standard. Even with respect to mere conduits, there's a recital to take care of that. You could say, well, that's only making sure that intermediary activity is basically the kind of activity that is provided by a recipient of the service. So it's basically, I think, kind of along the lines of what David was saying, that it doesn't really conflict because the intermediary activity by definition is excluding what is not coming from a third party, but is just done by the intermediary on its own. So you could say that is the reason, but let's see whether we understand it this way these days. And then you could say, well, many proactive services fall outside of Article 12 to 14 anyway, because of the way how they're technically drafted, so because of what kind of technical activity they target. So what is really the reason of adding additional layer of passive precondition there? What does it really solve? So I don't think it's completely clear of what is the purpose. And I think, let me visualize my thinking, because I know this is messy. So I think the common view, if you look at this, how this really works, is that you have this big line between what is your own content and what is the third-party content, right? And of course, ECD has it inbuilt that it's information provided by the recipient of the service, right? Because that's the intermediate character of the services, right? But this is not where we use and where we place our discussion of active versus passive, right? Because we could place it there. There's a language, right, provided by the recipient of the service. So easily passive could be test for whether it's provided by the recipient of the service. But that's not where we're placing it. We're placing it below, and we're basically saying, well, there's a still third-party content that is provided by the recipient of the service, but provider can behave actively with respect to it or passively with respect to it, right? They're going back to my diagram before. And the question is, okay, so that active part that is basically carving it out, what's the purpose of that? And if you believe in what I say here is that it doesn't seem to make sense if you try to safeguard any of these things because there are some other inbuilt mechanisms to take care of it, it's really questionable of what it is doing there. What are you trying to really do with this concept? So if you look at the case law, I think if this is the way you think of Papa Savas, I think it's spelled wrongly, which is a case about own content clearly, right? So there was a newspaper and its own article, and to what extent e-commerce directive applies there, clearly own content. eBay, well, it's a content originating from third party, but since eBay takes it and basically advertises on its own, there's in some member states clear idea that, well, content can originate from third party, but as long as you adopt it as your own, it's your own. So the fact that it comes from originally from someone else doesn't change much. The Pirate Bay, the Pirate Bay comes with the idea that there is a conscious and deliberate intervention in the communication of others. So the understanding of the court, it is actually the own content eventually because of the intervention. It's not anymore the third-party content, also because of the knowledge that is taking place there. But of course, so I think you could explain these cases as happening actually in the realm of own content already, not in the realm of third-party content. So you wouldn't have to make some additional artificial distinction between active and passive. But then there are these cases like Delphi and MTE and Article 13 DSM that Martin discussed in the morning, which clearly try to operate in this realm, right? So what they try to do is to try to say, well, it's a clearly third-party content still, but we nevertheless want to do something there to empty the e-commerce directive for in this area. And Delphi and MTE are just examples where you try to basically relabel the position of these players in order to be able to basically justify your more severe intervention, which in those cases it's a strict liability. But what about if we would think about it this way? What about if we would think about the active versus passive as being a question about whether that's your own content still or whether that's content of others? Could you maybe use this tool how to synchronize the interface with data protection law? Because you would say, well, if you're a controller, because you are actually determining the purpose, you're already becoming with respect to that content, of course, content is not the right word for data protection law, but you are actually becoming the addressee, and from that perspective, whether you are passive is only a question of whether that's someone else's action that you are concerned about. Is this something that would be workable, or do we have to think about it in these terms? And of course, if we have to think about it in this way, then of course some of the case law wouldn't really fit here, right? So Delphi clearly would be the case that I think many people would label as clearly third-party content, which should remain third-party content because the intervention, which is just opening up the comment section, is not necessarily sufficient to really label this as adoption of content as your own. And they would be clear outlier in this. So I hope this made sense to you. I was trying to be provocative, so I'm happy for your feedback, and I hope that instead of clarity I didn't bring even more confusion here. Thanks a lot.